Negotiable Instruments Act, Section 147, Offences to be compoundable. Section 147 of the Negotiable Instruments Act, 1881 provides that every offence punishable under the Act shall be compoundable notwithstanding anything contained in the Code of Criminal Procedure, 1973, thereby recognizing settlements and compromises between the parties. The provision was introduced to encourage amicable resolution of cheque dishonour and other disputes under the Act while reducing unnecessary litigation in commercial and financial matters. One purpose of Section 147. The main object of Section 147 is to encourage settlement between parties, reduce the pendency of cheque dishonour cases, and promote the speedy resolution of commercial disputes. The provision avoids prolonged criminal litigation where parties are willing to compromise and recognizes that cheque dishonour matters are primarily financial and commercial in nature. 2. Meaning of compoundable offence. A compoundable offence is one that may be settled or compromised between the complainant and the accused through mutual agreement. Where the offence is compounded, the dispute comes to an end, criminal proceedings are terminated, and the accused is discharged or acquitted in accordance with law. 3. Overriding effect of the provision. Section 147 begins with a non-obstant clause providing that it applies notwithstanding anything contained in the Code of Criminal Procedure, 1973. Accordingly, the special rule under the Negotiable Instruments Act overrides general criminal procedure provisions, allowing offences under the Act to be compounded even where ordinary procedural rules may differ. 4. Applicability to offences. The section provides that every offence punishable under the Negotiable Instruments Act shall be compoundable, including the offence of cheque dishonour under Section 138. It also extends to related offences under the chapter and broadly supports settlement and compromise in proceedings under the Act. 5. Importance in cheque dishonour cases. Cheque dishonour disputes generally arise out of monetary transactions and often involve claims for the recovery of money owed by the drawer. In many cases, the complainant is more interested in recovering the amount than securing punishment, and Section 147 facilitates settlement once payment or compromise is reached. 6. Benefit to parties. The provision benefits the complainant by facilitating faster recovery of money, avoiding prolonged litigation, and reducing legal expenses. It also benefits the accused by providing an opportunity to settle the dispute, avoid criminal conviction, and reduce the burden of continued litigation. 7. Role of court in compounding. Where the parties arrive at a settlement, the court may permit compounding of the offence and close the proceedings in accordance with law. Before doing so, the court ensures that the compromise is genuine, voluntary, and entered into without any improper influence or coercion. 8. Promotion of judicial efficiency. Section 147 helps reduce the burden on courts by encouraging negotiated settlements and minimizing the need for prolonged cheque dishonour litigation. This results in fewer pending cases, faster disposal of matters, improved judicial efficiency, and greater effectiveness from both administrative and commercial perspectives. For more details, contact us.